counsel.
And how does the confrontation clause interact with the rules of evidence, specifically hearsay? This seems like a complex and frequently tested area on the bar exam.
It's definitely one of the trickiest areas, governed by the Supreme Court's decision in Crawford v. Washington and its progeny. The core rule is this: testimonial out-of-court statements by a witness, meaning statements made under circumstances where a reasonable person would anticipate they'd be used in a later prosecution, that are offered by the prosecution as hearsay, offered to prove the truth of what the statement asserts, are barred by the Confrontation Clause unless one of two conditions is met. One, the witness is unavailable to testify at trial, and the defendant had a prior opportunity to cross-examine the witness about the statement, like at a preliminary hearing or deposition. Or two, the witness is unavailable because the defendant acted with the purpose of preventing the witness from testifying. This is the forfeiture by wrongdoing exception. So if it's testimonial hearsay offered for its truth by the prosecution, it's generally out under the Confrontation Clause unless one of those narrow unavailability prior cross-examination or forfeiture exceptions applies.
What about non-testimonial statements, or statements offered for other reasons?
An out-of-court statement that is not testimonial, like a casual remark to a friend, or a 911 call made primarily to get help during an ongoing emergency, is generally not barred by the Confrontation Clause, though it still has to meet standard hearsay exceptions to be admissible. Also, an out-of-court testimonial statement that is offered for a purpose other than proving its truth, for example, offered only to impeach a witness's credibility or to show the effect on the listener, is also not barred by the Confrontation Clause, because the clause is primarily concerned with the reliability of testimony offered for its truth without cross-examination.
Defining testimonial seems key then.
It is. Generally, a testimonial statement is one that the declarant would reasonably expect to be used in a prosecution. Think statements made during police interrogations, affidavits, or prior testimony. In contrast, a statement made for the primary purpose of assisting police in dealing with an ongoing emergency is generally considered non-testimonial. Think of a frantic 911 call describing a crime in progress, but a statement given to police after an emergency is over, perhaps at the station describing past events for the purpose of helping the investigation or prosecution, is likely testimonial. It's a very fact-specific inquiry based on the primary purpose of the statement.
That's a really fine but crucial line. And finally, a specific confrontation rule that often comes up in joint trials involving multiple defendants. The Bruton Rule regarding a co-defendant's confession.
Yes, the Bruton Rule addresses the problem that arises when two defendants are tried together, and one has confessed implicating both, but the confessing defendant chooses not to testify. The rule states that the admission of the confession of a non-testifying co-defendant at a joint trial violates the Sixth Amendment confrontation right of the other defendant, if the confession expressly implicates the other defendant. This is because the non-confessing defendant cannot cross-examine the co-defendant who made the statement, yet the jury might struggle to disregard the confession's implications against the non-confessing defendant, even with instructions. Such a confession is only admissible in a joint trial if all references to the non-confessing defendant are effectively eliminated or redacted, for example, replacing the name with another person or a neutral symbol. And a proper limiting instruction is given to the jury, telling them the confession can only be used as evidence against the defendant who actually made it. If effective redaction isn't possible, the trials usually need to be severed.
Let's consider due process more broadly now, and its role in ensuring overall fairness throughout the trial process. This is really the overarching principle that dictates the fundamental fairness required in the criminal justice system. What specific trial rights fall under this broad umbrella?
Due process, under the Fifth and 14th Amendments, ensures a fair adjudicatory process. Several key trial rights are rooted in this. For instance, defendants have the right to testify and present evidence on their own behalf. This is a fundamental aspect of mounting a defense. This includes the right to compulsory process, which means the defendant has the right, generally through subpoenas issued by the court, to compel favorable witnesses to appear in court and testify. In terms of burdens of proof, perhaps the most fundamental due process principle is that the prosecution must prove all elements of the charged offense beyond a reasonable doubt. This high burden, established in re Winship, reflects the value society places on liberty and reducing the risk of wrongful convictions. However, the burden of proving an affirmative defense, like insanity, self-defense, entrapment, or duress, may constitutionally be placed on the defendant, often by a preponderance of the evidence standard. Shifting the burden for affirmative defenses doesn't relieve the prosecution of proving the elements of the crime itself, beyond a reasonable doubt. Due process also means the court must acquit the defendant if the evidence presented by the prosecution is legally insufficient. The court may grant a motion for judgment of acquittal if, viewing the evidence in the light most favorable to the prosecution, there is insufficient evidence for a rational jury to reasonably find the defendant guilty beyond a reasonable doubt.
And then, after a conviction, we get to sentencing, the final judgment of the court. What rights apply specifically at this critical stage, and how does the jury trial right we discussed earlier extend into sentencing decisions?
Sentencing is definitely considered a critical stage of the prosecution. Therefore, applicable rights at sentencing generally include the right to counsel, the right to confrontation, and the right to cross-examination, regarding information presented specifically for sentencing purposes, although the rules might be slightly relaxed compared to the trial phase. And critically, as we touched upon with the Apprenda-Blakely cases, any fact, other than the fact of a prior conviction, that can be used to increase the statutorily prescribed maximum sentence for an offense must be charged in the indictment, submitted to the jury, and established beyond a reasonable doubt. This means factors that trigger mandatory minimum sentences might sometimes be found by a judge, but factors that increase the maximum possible sentence beyond what the jury's verdict alone authorizes generally must be found by the jury under the reasonable doubt standard. This significantly impacts how sentencing guidelines and enhancements operate.
And finally, wrapping up trial and sentencing issues, the Eighth Amendment prohibition against cruel and unusual punishment. What does this actually prohibit in practice, both for prison sentences and the death penalty?
The Eighth Amendment prohibits punishments that are cruel and unusual. For non-death penalty sentences, this prohibition is rarely violated based on the length of the sentence itself, unless the sentence is grossly disproportionate to the crime, committed a very high standard that's seldom met. More commonly, challenges arise regarding the conditions of confinement. Physical conditions in prison might amount to cruel and unusual punishment only if the prisoner can show both that the conditions posed a substantial risk of serious harm and that prison officials acted with deliberate indifference to that risk, meaning they had actual knowledge of the risk and disregarded it. For capital punishment or the death penalty, the Eighth Amendment imposes much stricter limitations. The death penalty can only be imposed under a statute that provides clear and objective standards to guide the jury's discretion, requires consideration of mitigating circumstances, provides specific and detailed guidance, and allows for meaningful appellate review of the process. This ensures that the death penalty is not applied arbitrarily, capriciously, or discriminatorily. The court has also categorically excluded certain offenders, like juveniles and the intellectually disabled, and certain crimes, like non-homicide offenses against individuals, from eligibility for the death penalty.
Okay, we're almost through our comprehensive deep dive into criminal procedure. Let's wrap up with some critical post-trial considerations, starting with double jeopardy, that fundamental idea that you can't be tried twice for the same crime. What exactly does this protect against?
It is a fundamental protection, rooted in the Fifth Amendment. The double jeopardy clause provides three core protections. 1. Protection against a second prosecution for the same offense after an acquittal. If the jury finds you not guilty, the government cannot appeal or retry you for that exact crime. 2. Protection against a second prosecution for the same offense after a conviction. Once you're convicted and punished, they generally can't try you again for it. And 3. Protection against multiple punishments for the same offense, imposed in a single proceeding. You can't be punished twice for one crime. The Blockberger test we discussed earlier is typically used here too to determine whether two or more crimes charged in the same or successive prosecutions constitute the same offense for double jeopardy purposes. If each crime requires proof of an element the other does not, they are generally considered separate offenses.
When does jeopardy attach legally? Meaning, when do these protections actually kick in during the process? This is a crucial timing question.
It is. The point jeopardy attaches is different depending on the type of trial. For jury trials, jeopardy attaches when the jury is impaneled and sworn in. For bench trials, trials by a judge alone, jeopardy attaches when the first witness is sworn in and begins to testify. Once jeopardy attaches, the protections against retrial for the same offense generally apply, unless the first trial ended for reasons that don't trigger the bar, like a mistrial declared due to manifest necessity, example, a hung jury, or at the defendant's request.
What does double jeopardy not prevent? What are some common misunderstandings about its scope?
It's important to know its limits. It does not preclude prosecution of the same criminal act under both federal and state law. This is a consequence of the dual sovereignty doctrine, which holds that the federal government and each state government are separate sovereigns, and each can prosecute an offense that violates its own laws, even if based on the same conduct. So you can potentially be prosecuted for the same act in both state and federal court without violating double jeopardy. It also generally does not preclude criminal punishment and subsequent civil penalties, like fines or forfeitures, for the same conduct, as long as the civil penalties are not deemed purely punitive in nature.
Okay. And what about the process of appeal after a conviction? Is there a constitutional right to appeal your conviction, or is it something granted by law?
Interestingly, the right to appeal a criminal conviction is not guaranteed by the Constitution itself. It's generally a right granted by statute. However, if a state does grant a defendant a first appeal as of right, which virtually all states do, then the Constitution, through the Equal Protection and Due Process Clauses, guarantees certain rights during that first appeal. This includes the right to appointed counsel for indigent defendants and the right to equal access to the appellate process, like free transcripts if needed. But for subsequent discretionary appeals, appeals that the higher appellate court can choose whether or not to hear, like appeals to the Supreme Court, an indigent defendant generally has no constitutional right to appointed counsel unless the conviction was originally based on a guilty plea or a nolo contender plea.
And how do errors actually get preserved for appeal? What happens if your lawyer misses an objection during the trial? Can you still raise it later?
Generally, an error must be preserved by a timely and specific objection at trial to be considered on appeal. This is the contemporaneous objection rule. The idea is to give the trial court a chance to correct the error right then and there. If an error was properly preserved, the appellate court will review it, but it won't lead to reversal if it's deemed harmless error, meaning the error did not affect the defendant's substantial rights and did not contribute to the conviction. The burden is usually on the prosecution to prove harmlessness beyond a reasonable doubt for constitutional errors. If an error was not preserved by an objection, an appellate court can still potentially review it under the plain error doctrine, but this is a much harder standard to meet. A defendant who failed to preserve a claim of error is generally only entitled to appellate relief if they can show 1. The district court committed an obvious error under the law in effect at the time the appeal is heard. 2. The error affected the defendant's substantial rights, meaning it was prejudicial and likely impacted the outcome. And 3. The error seriously affects the fairness, integrity, or public reputation of the judicial proceedings. Plain error relief is rare.
Finally, after appeals are exhausted, there's habeas corpus, a powerful but often misunderstood writ that allows a defendant to challenge the legality of their detention. What's its purpose?
After an unsuccessful direct appeal, a defendant can attack the lawfulness of their detention through a petition for a writ of habeas corpus. This is technically a civil action, not part of the original criminal case, where the defendant, the petitioner, claims their imprisonment violates the Constitution or federal law. Because it's civil, the preponderance of the evidence standard generally applies. Federal courts reviewing state convictions on habeas corpus apply very deferential standards under federal law, AEDPA. To grant relief, the court generally has to find not just error, but that the state court's decision was contrary to or involved an unreasonable application of clearly established federal law, as determined by the Supreme Court, or was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. Even if constitutional error is found, relief is often only granted if the error had a substantial and injurious effect or influence on the verdict. It's a last resort mechanism focused on correcting fundamental constitutional errors that led to unlawful detention.
We've truly taken a deep dive today into criminal procedure. Wow. From the intricate dance of a Fourth Amendment search and seizure, all the way to the critical distinctions between the Fifth and Sixth Amendment rights to counsel, and through trial and post-trial. Understanding these nuanced rules isn't just about passing an exam, although that's important for many of you listening. It's really about grasping the core protections afforded to individuals in our justice system and how the law tries to balance individual liberty with public safety. Remember, the absolute key to mastering this material, especially for something demanding like the bar exam, is to understand the frameworks. When you're faced with an essay question, really follow the call of the question. If it's specific, asking about, say, just the Miranda issue, organize by that question. If it's more open-ended, discuss the constitutional issues, then organize your answer methodically, usually by defendant, if there are multiple, and then by constitutional right, 4th, 5th, 6th, etc. This structured approach is absolutely crucial for a clear, logical, high-scoring analysis.
Exactly. And then A good tip is often to identify the potential remedy the defendant is seeking before you dive deep into the right itself. Think, what does the defendant want here? Often it's the exclusion of evidence. So, maybe start your analysis by considering the exclusionary rule. Mention it applies to violations of Fourth, Fifth, and Sixth Amendment rights via the 14th Amendment. Briefly touch on the fruit of the poisonous tree doctrine and then immediately flag any potential exclusionary rule exceptions that might apply on the facts, like good faith, inevitable discovery, etc. Laying that groundwork first can be really helpful. Only then do you identify the specific right that was potentially violated. Was it the Fourth Amendment's protection against unreasonable searches and seizures? The Fifth Amendment's protection against compelled self-incrimination, which brings in Miranda, or the Sixth Amendment's right to counsel at critical stages, or maybe other rights like confrontation, speedy trial, double jeopardy.
Right. And then the final step is to tie the specific violation you found back to the specific consequence or remedy, considering those exceptions. For a Fourth Amendment unlawful seizure, maybe the defendant is released, or evidence found during it is suppressed. For an unlawful search, the evidence is typically excluded, subject to exceptions. For a Fifth Amendment Miranda violation involving the right to silence or counsel during interrogation, the resulting confession is excluded from the case in chief. But remember, derivative physical evidence might still come in, and the confession itself might be used to impeach the defendant if they testify differently. For an involuntary Fifth Amendment confession, coerced, that's a much more severe violation under due process, and all evidence derived from it, including physical evidence, is likely excluded as fruit of the poisonous tree. And for Sixth Amendment violations like improper questioning after charges or denial of counsel at a critical stage, typically all evidence obtained as a result, statements and physical evidence, is excluded as fruit, though again, it can potentially be used for impeachment. Plus, remember those specific remedies for Sixth Amendment denial of counsel? Conviction at trial often equals automatic reversal. A guilty plea entered without counsel can usually be withdrawn and is excluded. And denial at a non-trial proceeding often gets harmless error analysis.
This intricate web of rules and exceptions, it can seem daunting, absolutely. But it's designed, at least in theory, to protect fundamental liberties while still allowing for effective law enforcement. And as technology continues to evolve at lightning speed and our societal understanding of privacy and police powers adapts, it really raises an important question for the future. How might these foundational Fourth, Fifth, and Sixth Amendment principles continue to be interpreted and applied by the courts, especially as new challenges to privacy arise from things like AI, ubiquitous surveillance, genetic databases? This area of law is always in motion. It demands constant critical thinking and a willingness to explore the implications beyond just the text of the cases we have now.
Keep those study sessions going strong, everyone. And remember, the real joy of discovery here is in connecting these seemingly disparate rules and cases into a coherent and powerful understanding of how our system works and why it matters. You've got this. We'll catch you on the next deep dive.